And would you mind, Mr. Day, to talk a little bit about the trust, how trusts are, different? And again, pardon my ignorance, but I wanted that to be, useful information for the listeners. How trusts are different than these senior liens. That I mean, what are the different components of these?
Yes. So all the business entities that all your listeners are used to, the corporations, LLCs, and limited partnerships, are considered separate legal people under the law. You have to treat your own company as if Kevin Day owns it. If you are an employee of your own company, you need to sign both as the employee that you're accepting the deal that you've negotiated with yourself as president or manager. The corporations code and the IRS code says that you have to work with these entities as if they were third-party owners. But they have to have an owner. They have to have a shareholder or a member. So in our legal system, there's only two ultimate owners: a flesh and blood human, nobody owns you, and nobody owns a lawsuit-proof trust. It is an ultimate owner. Nobody owns it. You'll have a beneficial interest in it, and that's what you want. That's the good end of the stick. But a corp can be owned by an LLC that's owned by an LP that's owned by a corp. It will not end until it hits you, or a lawsuit-proof trust. So to get real lawsuit protection, you do not want to be the technical owner. Humans, we drive cars. We have a woman client that just came to us recently, and she hit a pedestrian. There was a very large claim. She has 2 apartment buildings, and so it wasn't a faulty smoke detector or somebody getting electrocuted. And these are actually 2 cases that we had in the last 4 years against our clients. And luckily we had senior liens, so even the building that harmed them wasn't able to be taken away. This is coming in the back door. She had this car accident, and they're saying, okay, what do you own? She actually doesn't own real property. She owns LLCs that own the real property. So they come through the back door down the ownership chain. And this is where lawsuit-proof trusts come in, where under penalty of perjury, list everything you own. She doesn't have to she doesn't have to list those companies that are in her estate, but are technically owned by a lawsuit-proof trust, which she's the full beneficiary of. So she gets all the income. She can buy and sell the properties when she wants to, so forth. So passive investment is like cash. Or like a portfolio. It just happens to be in real estate. And you don't want some incident happening to you personally and them coming and ultimately saying, oh, do you have any investments in other people? Do you have any notes payable to you? Any of those things. You want to be able to say, no, I own my home and car. And as you can see, I'm up to my eyeballs in hock. There's nothing to take.
So along with the so what you are really saying, and correct me if I'm wrong, if I heard it wrong, you are saying is that along with the trust, and these senior liens, you can potentially protect yourself in all the possible scenarios where any legal lawsuit that could come towards you because of the senior lien, you can protect your assets, and obviously because of the trust, you could still maintain the privacy and protect your assets.
Yes. Those are 2 different strategies, but working together exactly as you outlined means that we have protected you and your assets from internal liability, those things inside any companies, but also for anything that might befall you personally. So from internal liability as well as from external liability. And what we do, we don't want to rely on secrets. The way I define secrets is that if we told a judge or the adverse party what we did, all of a sudden it unravels and they can get to it. We want privacy, not secrecy. We want privacy because, as I said, 80% of the time, adverse parties don't see the structuring we've done in the liens related to our client. But in the 20%, I should be able to go before a judge and say, this is what we did, and this is exactly when we did it. They hadn't harmed anybody yet. The only way to unravel a lawsuit-proof trust is to allege and prove fraudulent conveyance. They had to have had already harmed someone. And we did this a year and a half ago. It's impossible to unwind this now. So we don't want to rely on secrets. Privacy is good, but I should not be embarrassed to tell a judge the work we've done.
Awesome. Awesome. So